Assalamualaikum warahmatullahi wabarakatuh. My name is Nik Asima Atira binti Ghazali. My matric number is 070904. So the law of defamation in Malaysia is primarily based on the English common law principles, except insofar as it has been modified by the Malaysian Defamation Act 1957. The Malaysian Defamation Act 1957 is imparallel with the English Defamation Act 1952 that does not define what is defamation. It seems to adopt the common law definition that defamation is the publication of a statement which reflects on a person's reputation and tends to lower him in the estimation of right-thinking members of society generally, or tend to make them shun or avoid him. Defamation arises when there is a publication which has a tendency to lower the person's reputation, to cause him to be shunned or avoided by a reasonable person in society, and thereby adversely affecting his reputation. Defamation is established if X and Y either orally or in writing that Z is a dishonest and selfish person who like to take advantage of those around him. Publication arises when this statement is made to Y, and as this statement makes a reasonable person to disassociate himself from Z company, it therefore adversely affects Z reputation. The interest that is protected by this law is a person's good names and reputation. The feeling of hurt, however, is insufficient for the award of damage under the thought of defamation. Words spoken in jest and are understood by those who hear them to be so is not defamatory, as the word should not affect the plaintiff's reputation. After that, types of defamation may be divided into two different types, namely libel and slander. In England, libel is a thought as well as a crime, whereas slander is only a thought and not a crime. In Malaysia, libel and slander are both thought and crimes. Firstly, libel, which is defamation in a permanent form and is usually visible to the eye, such as items and writing which include email, picture, SMS, status, or averages. Section 3 of the Defamation Act provides that the broadcasting of word by means of radio communication shall be treated as publication in a permanent form and therefore constitute a libel. Libel is actionable per se, which means that a plaintiff need not prove any damage. This is because the law presumes that when a person's reputation is assailed, some damage must result. Secondly, slander is defamation in a temporary or transient form. Publication is usually made through spoken word or gesture. A slander is not actionable per se. The plaintiff therefore need to prove actual or special damage in order to succeed in his action. There are exceptions to the requirement of actual damage in cases of slander. General rule, slander is not actionable per se. However, there are some exceptions whereby slander may become actionable per se. They are as follows. Firstly, slander to women. Section 4 of the Defamation Act 1957 provides that the publication of words which impute adversity or adultery to any woman or girl require no proof or special damage for the action to succeed. Lukainam versus Sim Island, the respondent called the appellant a prostitute and said that the appellant charged RM15 to entertain men at any one time. These allegations were made in the presence of a third party. The court held that since the word impugned the appellant's chastity, special damage need not be proven. Slander was established. Secondly, slander in relation to a person's professions or business reputation. Section 5 of the Act provides that words that are calculated to disparage the plaintiff in any office, professions, calling, trade, or business held or carried on by the plaintiff at the time of the publication are actionable per se. Disparaging the plaintiff excludes the imputation of unfitness, dishonesty, or incompetence, and is actionable whether or not they are spoken of the plaintiff in the way of his office, professions, calling, trade, or business. In case of John Tan Chong Leong versus Lee Chan Tiang, the plaintiff, who was an advocate and solicitor, claimed that the defendants were to the plaintiff friends and clients to the effect that the plaintiff was owing him the defendant's 7 months' rent were defamatory, as the words were calculated to disparage him in his office. Applying Section 5 of the Defamation Act 1957 in favor of the plaintiff and so holding that the defendant's case was actionable per se without proof of special damage, held it is unnecessary to prove special damage even if the words are spoken of the plaintiff so as to affect him in his professions. Thus, it will now be actionable per se to impute insolvency to a solicitor. Thirdly, imputation of a contagious disease. To impute the plaintiff of a contagious disease so as to prevent other person from associating with him is slander, actionable per se at common law but not in Malaysia. The word must infer that the plaintiff suffers from such a disease at the time publication is made. Therefore, if the plaintiff is no longer suffering from such a disease, then the slander may become not actionable per se. Or, imputation of a crime, slander is actionable per se if the words indicate that the plaintiff is involved in a crime. The crime must be one which attract corporal punishment, which exclude the death penalty, whipping, and imprisonment. Imputation of an offence punishable by fine merely is not sufficient. The rationale or basis of this rule is that reasonable persons are likely to shun and avoid someone who is convicted person and whose punishment is serious. In case of Sivanathan versus Abdullah bin Dato Haji Abdul Rahman, the defendant called the plaintiff a cheat, dishonest, and a liar. The court held that since the crimes did not attract corporal punishment, the plaintiff claim was not actionable per se. His action failed as he could not prove special or actual damage.
Assalamualaikum warahmatullahi wabarakatuh. My name is Iman Damia binti Rosli and my metric number is 0714877. So, there are some ways to overcome the online defamation, where one of it is to not respond to your defamer, which with this way, it will prevent from any information to be leaked and any false statement to be stated. And people usually was not in the right state of their mind when it comes to times like this, and will do some rush action which may result in something unpleasant. For example, people would be wondering why would you panicking over a news or something that wasn't true about yourself, like in the case of online defamation, and it was a really bad result for the rush action. And if we follow this way, it will prevent from the decreasing numbers of the online defamation cases.
Hi and Assalamualaikum. My name is Yasmin Alia binti Muhammad Rizal and my metric number is 0711129. I will explain more about the other ways to overcome the online defamation, which is preserve the evidence and adjust your privacy settings. Evidence is required if you want to file a defamation lawsuit over social media libel. Make sure that you save or copy the defamatory statements by taking screenshots or pictures with your phone. A defamatory statement or post could be removed at any time, either by the creator or the platform. Therefore, saving a copy is extremely important. You cannot file a lawsuit without proof of defamation. If you see a defamatory statement online, you should immediately take a screenshot of the content and copy and paste the URL to preserve it. If possible, it is also important to use a service that retrieves, including the correct URL, date, and time that the content was viewed, so that the evidence can be admissible in court. While the author might delete the post, the effect of the post can be long-lasting, and without some sort of admissible evidence to show the actual defamatory statements, your case will be difficult to win. While you are preserving the evidence of the defamatory content and/or profile, you should also consider adjusting the privacy settings on your account or closing your account entirely. This can sometimes prevent others from piling on and tagging you in follow-up posts using your existing data and imagery to add to the harassment and can potentially motivate the damage being caused.
Report and request removal of defamatory content. Most of platforms such as Twitter and Facebook provide a way for you to report or flag content that violates their terms of service or standard, such as nudity, violent content, racist remark, or bullying statement. When you do report offensive or defamatory content to a social media platform, be prepared to explain why it is defamation or why the content violates the platform's rule. Ultimately, it is up to the online platform to decide to remove content. Most often, unless it's a clear violation of their terms of service, the platform will not take action. Social media platforms do not want to be the judge and jury deciding what constitutes defamation and what does not. They would prefer to leave that decision up to the court. Is the social media platform determine the content does not violate their community standard or guideline or ignore your flag and report requests, you may need to work with an internet defamation attorney to pursue legal remedies.
Last but not least way to overcome the online defamation is to consult with an attorney experienced with internet defamation matter. This is because they are an expert in defamation law. Legal issues related to the copyright, harassment and stalking, obscenity, and interactive computer service may all be heavily intertwined with cases of internet defamation. Working with the top internet defamation lawyer put you in touch with a group of professionals who deal with this issue on a daily basis and can quickly and effortlessly decide your best legal option. With their knowledge, internet defamation lawyer can help you save time and money. The online defamation lawyer also can be called as tech savvy because they're keeping a brief of the most recent technological development, as it is crucial for identifying anonymous internet trolls, summoning internet service provider, and preserving potentially ephemeral evidence. They also understand how to use the popular website and discussion board that predators use to slander others. Establishing a cooperative relationship with website owner, third-party arbitration companies, and other online news, media, and publishing organization is necessary for this, as it also have the cases. Also, they also very have deep understanding on online extortion. They are proficient in all forms of online attack, including online extortion, and are able to use the tech-savvy unmasking method and online investigation service to find online harassers, cyber stalker, and extort money from them in order to hold them accountable for their action.
Okay, so we already talked about what is online defamation and how to overcome it. But what does this defamation look in real life? I give two examples of online defamation cases. First one is in the case of Muhammad Haidar Ahmad and Muhammad Iqbal Zainal Abidin. The defendant had alleged that the plaintiff, who is an assistant district officer of Temelloh, had a business power and was corrupt among others. One of the Facebook postings had an upload photograph of the plaintiff, his son, and his car, and also defamatory statements. These Facebook postings attract negative response from netizens on his Facebook page. Defendant denied that these words were defamatory of plaintiff, that they only were fair comments, and disclaimed responsibility for the negative comments by the netizens. The Court of Appeal upheld the High Court decisions in dismissing the defendant's defense and upheld the damage of 15,000 ringgit granted by the High Court. The second case is in Datuk Sri Muhammad Najib bin Tun Haji Abdul Razak and Tony Puah Kiawi. The plaintiff, who is the former Prime Minister of Malaysia, sued the defendant, who is a member of the Parliament of Malaysia, for defamation. The defendant had allegedly published defamatory statements on a live video, which was published as a post entitled "BN Government Abandons All Bills to Give Precedence to Pass RU 355 Private Member States" on his Facebook account. The Facebook post went viral. Plaintiff also filed an application for interlocutory injunction to stop defendant from uttering or publishing the defamatory statement. The High Court granted the said application and held that the defendant did not deny he had published the alleged statements, and such statements are indeed defamatory. To sum up, as a final analysis, defamation is an act of crime because the purpose of this act is to bring down specific people's reputations. It has so many consequences like giving mental breakdowns to the defamed people, and this can create chaos and problems in the community if it is not controlled. Defamation is a serious thing to look at, and people must not underestimate this issue. Luckily, the government has been concerned with this and has made many laws about it. Also, it is an unbeneficial act to do because in defamation, nothing good comes from it. Moreover, you will just only get punishments. Last but not least, we are also responsible to avoid defamations. There are so many ways to overcome it, and that has been discussed before. If we do not start, who else?